Banga sir, Dr. Ajay Patil sir, and Dr. Sandeep Kodu, Control of Examination of MUHS, will deliver lecture on different aspects of medico-legal issues. From the beginning, I should start. I invite Dr. Rajendra Banga sir, Registrar of Maharashtra University of Health Sciences. Besides that, he is a medico-legal consultant and forensic expert, professor and head of the Department of Medical Jurisprudence and Forensic Medicine, advisor of Medico-Legal Association of Maharashtra, member of National Advisory Board, Indian Academy of Forensic Medicine, member Board of Research, MUHS, member Ethics Committee, MUHS, editor emeritus of Journal of Forensic Medicine, Science and Law. He was the Dean of Srimati Kashibai Noble Medical College and General Hospital, Pune, member of the District Consumer Disputes Resolution Forum, Navi Mumbai. He was also the editor-in-chief of Journal of Forensic Medicine, and he is a recognized PhD teacher and guide for MD and Forensic Medicine and PhD guide. So, at the beginning, I request Dr. Rajendra Banga sir to kindly deliver his lecture on the pitfalls in clinical documentation.
Yes, sir. Thank you, Dr. Swapnil.
Yes, sir.
I welcome you all on behalf of Department of Ayush at MUHS. Now, this particular topic is not specific to any faculty. It is applicable to allopathy, Ayurveda, homeopathy, all those registered medical practitioners who are actively participating, practicing. So this is valid to them. Swapnil, shall I need to share the screen. Wait, 1 second.
Sir, you can share screen.
Is it visible?
Yes, sir. It is visible.
Okay. So shall I start?
Yes, sir.
Okay. So a very good afternoon. Pitfalls in clinical documentation. This is today's topic. Now, why, madam, the entire screen is visible? Hello? Hello? Torne sir?
Yes, sir. Sir, तुमचं म्यूट आहे.
Is the entire screen visible?
Yes, sir. Now the screen is visible.
Yes, sir. So these are the two important aspects of clinical documentation, because whatever we write as a medical practitioner, we are responsible for it. And secondly, whatever we write is accessible not only to the patients, but also to the relatives, to the lawyers, to the court, to other doctors, and to everybody. So here is the importance of responsible documentation. 1 second. Yeah. Now, when we were medical students, maybe in 1980s, these words were not heard of. However, in today's era, before starting a clinical practice or establishing a hospital, all these words, quality assurance, audits, accreditation, so we have to take care of all these words, and these are not taught in medical syllabus. Now, what is the necessity of proper documentation? There are two necessities: medical necessity, whosoever may be, or whosoever senior may be that physician or surgeon, whosoever confident he may be in his clinical practice or surgical skills. However, quality without documentation is a myth. If someone says that yes, I have surgical skills par excellence, and I need not document, his quality will not improve. So quality without documentation is a myth. One has to document to maintain the quality. And the legal necessity is what is not documented never happened. So best defense against litigation is documentation. And that's why the importance of this proper documentation. Now, if you see this slide, I have taken this from some clinical case papers. The doctor has advised plain CT scan. You can see on this corner, plain CT scan of left shoulder for fracture of right humerus. So this is the order given by that doctor, and this is dated, I think you can see the date on the right upper corner. Next day, the doctor has prescribed CT scan left shoulder for fracture of right femur. So this is the level of documentation. Now this is a hospital which is a corporate hospital. However, there is no proper attention to the documentation that is must. Now many authors, they tend to differentiate between medical and medico-legal documentation. According to them, great care should be taken in medico-legal documentation, and they are casual towards medical documentation. However, I differ from their opinion. For me, each and every documentation, whatever it may be, has a medico-legal significance. Each full stop, each comma, each punctuation you write in the clinical case records does have medico-legal significance, and the clinical documentation should not be taken casually. Now, why it is necessary, or what is responsible documentation? By responsible documentation, I mean that from your clinical records, the way you maintain it, the way you write it, your expertise should be visible. Your experience should be visible. Your seniority should be appreciated just by looking at the records or clinical notes that you maintain. So it should be clear on the face of the clinical records, your seniority, expertise, and experience. Many times when I used to teach in maybe at around 1995, 6, 7, 8. So I used to say to the students that you learn everything from your seniors. Learn how to diagnose a patient, how to elicit signs, symptoms, but never learn documentation from your seniors, because they were really bad at it. However, now those students to whom I taught in 1990, now they have become seniors. So I have stopped giving them that advice, because I hope that they have improved in their documentation. Now, documentation is nothing but written communication. There are various means of communication, including verbal communication, communication by gestures, by body language, and documentation is one of the ways. It is called as, I call it as written communication. Now, in this particular case, I think in 2016, this particular case was widely circulated amongst the WhatsApp groups in doctor communities, and all doctors were very elated. They said that at last there is some court order which is in favor of doctors. Now, in this case, what had happened is a doctor on duty had consulted, or had one consultant for see a patient, and that consultant was yet to arrive. But before that, this particular duty doctor, he left the ward. He moved out of the hospital, hoping that the consultant will come soon. However, there was some delay for the consultant to arrive. And in the meanwhile, some mishap happened. The case went to the court. The court said, the doctor pleaded or defended himself that as my duty was over and I had to have my meals, that's why I left the wards. So the court said, like other normal human beings, doctors also need to take rest and their meals and then get ready for the duty to be performed on the next day. So this particular line was circulated widely on the WhatsApp. However, what was not circulated or what were the contents of that particular order, that is, the court had said that yes, you can leave the hospital without waiting for the consultant, provided that you have documented all the clinical signs, symptoms, diagnosis, everything, your thoughts on that patient, your observation, clinical observation into medical records. And this is the significance of medical records. If you have not written everything in detail for the consultant to appreciate, you cannot move out of the hospital. Then in that case, you have to wait till the consultant arrives and then you can brief him about it. The doctor treating the patient in the absence of the previous doctor is a competent doctor. He should have no difficulty in treating the patient on the basis of the records prepared in the hospital. So in this particular case, had the records not been maintained properly, this case would have been decided against the doctors. Now, the history taking is, as you say, doctor should be a good listener. So whatever the patient says, it should be meticulously and perfectly written down into the case papers. And not only the history, but also, so in this case, the patient was a non-convulsive patient in the wards, and on the third post-operative day, he had minor, it was described as minor convulsion. And this particular incidence of minor convulsion was not recorded in the case papers. The doctor has described that being a minor, it was not mentioned. So the court held that convulsion is a big event for a non-convulsive patient, and trivializing it as a minor event was improper. So no sign or symptom, however minor it may be, should be omitted for documentation. Negative history is more important than the history given by the patient. Negative history is to be elicited by the doctor. And the more experienced or more professional that doctor is, the more differential diagnosis he will keep, and then he will rule out one by asking relevant questions to the doctors. So here is the importance of eliciting negative history. Results of investigation must always be recorded in time. Generally, all the nursing staff or the junior doctors, they do write what investigations were advised to the patient, but then they fail to write the results of the investigation. So all reports are should be documented. Sometimes it so happens that you send the reports, maybe for example culture reports, and they arrive after 2 or 3 days. Till that time, the patient is either discharged or dies. In that case also, all such reports, even after discharge or death of the patient, should be meticulously collected, compiled, and filed in the patient's folder. All prescriptions should be written in capitals. The form of the medication, whether it is injection, tablet, rescue, should be mentioned. The dose, the duration, the strength, the frequency, route of administration must be mentioned. There is a format of prescription that is prescribed by NMC, and that should be followed. In this case, the surgeon had stated in his defense that he had calculated the dose of the patient, pediatric patient, based on his weight of the patient, as it happens in all pediatric cases. However, the court held him negligent on finding that the patient's weight was nowhere recorded. So his defense that the dose that was calculated was based on the weight of the patient was not accepted by the court because the weight was not mentioned in the clinical records. All phone calls must be documented, must be recorded. Whatever conversation so happens between the duty doctor and the consultant, all the instructions, advice, suggestions that is given by the consultant must be reduced to writing in the case paper. And one more thing, the consultants should not make a phone call or advice to the nursing staff, but they should talk to the duty doctor. Then duty doctor will reduce it to writing in the clinical case papers, and then he will instruct the nursing staff. It's a habit amongst many doctors to write so and so doctor was informed, but they fail to write what was actually informed. Whether they inform about the investigation report or the clinical condition of the patient, so they do not mention that, and also they fail to write that after this information, what advice was suggestions or instructions were given by the consultant to them. So this type of casual documentation should be avoided. Informed consent. Now, if you see this particular word, informed, this phrase, informed consent has two words, information and consent. So amongst these two words, information is more important than consent. Whatever information the patient requires has to be given by the doctor. Doctor is duty bound to give the information, and based on that information, then the patient consents. There was a study carried out about whom we call as a poor quality doctor. Who is a poor quality doctor? So in that study, it was observed that many patients, they feel that a doctor who does not listen or who is inattentive is a poor quality doctor. The qualification or the experience or the expertise or the seniority of that doctor did not matter to the patient. So here lies the importance of listening and being attentive and then documenting everything what has been listened. In this case of informed, very good example of informed consent, when that MTP was carried out after 8 weeks, but the patient remained pregnant even after that MTP, even after D&C was carried out, and that case went to the court. But the doctor was very particular, and she had mentioned in the consent form that the percentage of failed MTP in the first trimester was 0.94% and second trimester was 2.43%. Therefore, 100% termination of pregnancy was a myth. And this was a sentence which was included in the informed consent form that defended that doctor. The case was dismissed by the court. Now, situations in which consent becomes invalid. First is oral consent, though legally oral consent has the same validity as written consent, but it cannot be proved in the court of law. And if it is not proved, then it is no consent. Also, a blanket consent is bad in law. Blanket consent means you obtain consent for everything. Means right from surgery to removal of organs to postmortem, and everything is consented by the patient. Such blanket consents are bad in law. Or if the act consented to is unlawful. For example, criminal abortions. If you take consent, it is bad in law because the act what you are doing is itself criminal. Patient signature is obtained on a consent form written in a language that the patient does not understand. So always the consent has to be in the language in which the patient understands. Also, the consent will become invalid if signature of the patient is obtained when she is either under effect of sedatives, or she is under stress, she is in labor, or having some organic brain disease, or in such situation, for example, she is being wheeled into the operation theater or into the labor room, and at that time you take the consent. So such type of consent are invalid. More examples are if it is not an informed consent, then it is no consent. Information has to precede the consent. Or if it is obtained by misrepresentation of fraud, if both mamuli surgery, you can go home within 2 hours. So such type of statements or misrepresentation or fraud should be avoided. If the patient is minor, of course, if he is mentally ill or does not have legal capacity, then also the consent becomes invalid, or patient is immature to understand the information. More important than informed consent are informed refusals. Informed refusals must be in writing. Now, as far as consent is concerned, consent can be implied or it can be written consent. Implied means it is understood. The consent is understood by the behavior or demeanor of the patient, and it is not in writing. But informed refusal has to be in writing. Informed refusal cannot be oral. It cannot be verbal. So all the implications of not following a particular procedure or getting discharged prematurely from the hospital or not following instructions of the doctors. So in all such cases, informed refusal must be taken in writing. One more important aspect of consent is the scope of consent. Many times, even if you take informed consent, proper consent in writing, but if the scope of the consent is too narrow or too small, and during some procedure, you need to extend the scope of the consent, by which time the patient is either sedated or anesthetized, you cannot do so. So the consent in the beginning itself should be, its scope should be broad enough to cover all the aspects, all the foreseen aspects. In this case, 44 years unmarried woman. Now she was had a prolonged menstrual bleeding, and the doctor took a consent for diagnostic and operative laboratory. So when this particular consent was taken, patient was being 44 years and adult, she gave the consent. But during the procedure, what happened that while the patient was still unconscious and there was too much bleeding, so an assistant doctor came to the out of the OT and obtained consent of patient's mother who was waiting outside. That consent was for performing hysterectomy, and thereafter bilateral salpingo-oophorectomy was also carried out. Here the consent was that of mother and not that of the patient, because patient was on table. So in such cases, in this particular case, the doctor has thought that the patient is unmarried. She is 44 years of age. So thinking that she may not get married or whatever might have been the thought process. But the hysterectomy and bilateral salpingo-oophorectomy were carried out. Now, after 13 days, when the patient was to get discharged, she did not pay the patient the fees, the medical bills, and she went away. So the doctor filed a case against the patient for recovery of fees. Also, the patient filed a case against the doctor for being negligent, for removing her uterus and ovaries, and the case was being decided in the courts. So in this particular scenario, the court held that in medical law, where a surgeon is consulted by a patient and consent of the patient is taken for diagnostic procedure, because he had taken the consent for diagnostic laparoscopy and then performed surgery. So it was no consent at all for surgery. Similarly, the consent by the patient is for a particular operative surgery. It cannot be treated as a consent for an unauthorized additional procedure. So this was the thought of the court, and then it commented that in this case, the consent by mother cannot be treated as valid or real consent. Even though she was her mother, there was no consent by the appellant for performing hysterectomy, and this case was decided in favor of the patient. The doctor had to pay compensation, but then the doctor went into appeal, and I think it was upheld by the appellate court also. Slide. Now, few suggestions, like in whenever you are treating or clinically managing a case, always seek consultation and encourage referrals and timely transfers, because this shares the medical legal responsibility. If you seek consultation and then come to opinion about a particular course of therapy, you get a shared, the responsibility gets shared. So here, in this case, the patient was referred to PGI Chandigarh. However, the relatives, they did not go to PGI Chandigarh. They took the patient to some other hospital. They wasted 2-3 hours, and then afterwards again the patient was referred to PGI Chandigarh. So documenting the advice given and the disregard shown by relatives is necessary in such cases, because the time was lost, and so doctor was not held guilty in this particular case. Whenever we wish to refer a stable patient, then all these things should be documented: date of referral, reason for referral, name of receiving hospital, clinical condition of the patient, referral letter, and SNDT. SNDT is sign, name, date, and time. SNDT has to be recorded in each and every entry. And while referring unstable patients, you also need to first stabilize the patient, document that the patient was stabilized, and then refer the patient. Also, while referring, you also mention the facilities available in the ambulance, the qualification of the doctor who is accompanying the patient, and also modes in transit. What all happened to the patient, what all happened while the patient was in transport, and again SNDT, that is sign, name, date, and time. Now, in this particular case, it was alleged that the patient had died much before the transfer, and the receiving hospital had clearly mentioned broad date on arrival. So the court found this allegation to be true based on the documentation of the patient. Now, also, we need to document any non-compliance on the part of the patient. That is, not following written order as to medications, not doing advised investigations, not following dietary advices, self-medicating patients even when they were told not to do so, and not turning about follow-up. Now, all these things we come across often during our practice, but those go undocumented, and that creates a problem. This is our one of the major defenses while in case of medical negligence. In this case, the doctor stated in his defense that he had applied plaster. The doctor told him to come after 5 days, but the patient returned after 2 months. That too, he had removed the plaster on advice of some other doctor. So, such things should be documented. Those are our defenses. In this case, the patient's relatives produce certain information downloaded from the internet. This is often common nowadays, but the doctor was quick to point out that such information which is downloaded from the internet was for use of a person who is self-medicating and not for a qualified doctor. So you can also raise such defense in case such phone calls. Oral communications should be documented promptly and timely. All such circumstances which are, if you feel that are unavoidable, should be documented. For example, a paralyzed person who is overweight, who is diabetic and bedridden. Also, there is a catheterized patient, or there is a leakage. So, in such cases, bed sores are almost unavoidable in Indian situation. So, such circumstances leading to unavoidability should be documented. Now, there is a very typical habit of all the doctors to write in the margins. Means, I will show you some pictures. Now, see this. All the important documentation. What happens in the court of law? The originals are not produced. Photocopies of the originals are submitted to the courts. Originals remain with the hospital. So, the courts or the lawyers or other doctors, they fail to appreciate what has been written in the margins. You can see all these values are there, and I don't know, there is a habit amongst the doctors to write at the extreme border of the page. So this habit should be typically avoided. Proper correction. If there is an error, then there should be a proper correction and include allergies and any prior adverse reactions to medications or contrast media. This should be included. Any rationale for your decisions. For example, a general practitioner refers a case to you to a hospital stating that advise CT brain. Now you examine the patient in the hospital and you feel that the CT brain is not required in this particular case. Now that means that particular general practitioner who has referred the patient to the hospital, you are not following the request by him. So in this case, a rationale or a reason, proper reason for not going for that investigation should be mentioned in your clinical notes. Now, these should be avoided for medication errors. Misplaced decimal points, it should be very clearly mentioned. Always use 0 before decimal points. Before 0.5, you write 0.5. Do not use terminal zeros. Do not write 5.0 grams. So it may be misread as 50 grams. So these are some of the medication errors. Legible handwriting. Now, doctors are known for bad handwriting, but this bad handwriting of doctors has escalated from fun or ridicule to the courts. And this JACO has also defined what is bad handwriting. The inability of 2 out of 3 individuals being unable to read handwriting is bad handwriting. So you can check yourself whether your handwriting is good or bad. And it has been reported that almost 15% of medication errors report occur because of illegible handwriting, problems with leading or trailing zeros, misinterpreted abbreviations, and incomplete medication orders. So common mistakes, last few slides. No, if you don't write signature, name, date and time, not documenting on this oral and telephonic conversation, signing without verification of notes, not writing prescription in capitals, illegible handwriting, non-standard abbreviations, and continuity of care is not reflected in records. And few of the blunders, blank consent forms with patient signature. This is the blunder often found in medical records. Blank assessment monitoring forms with doctors' signatures, no advice at discharge, no follow-up advice, no disclaimers in lab or sonography reports, not advising anomaly scans, not advising to rule out retinopathy of prematurity. So all these blunders should be avoided. Okay, I will stop here. And if there are any questions, you can ask.
The house is open for the question and answer session. If anyone has the questions, please ask. Please raise your hand.
Hello, sir.
Yeah.
Myself,
Yes.
Dr. Sheetal.
Yeah, please speak loudly.
Hello, sir. Myself, Dr. Sheetal. Yeah, sir. I have one question.
Yeah.
Like you said, we need to document each and everything in a telephonic conversation also. Because I work in a hospital where sometimes what happens, consultant says that you don't do this thing, but don't tell this to patient's relative and all. So what to do at that time? Because it happens like majority.
No, you mean to say that the thing that is required to be done by the doctor for treatment of the patient.
Yeah, but because of maybe because of some financial issues or sometimes patients' relatives are very, you can say, violent and they are very aggressive. So doctor asks us to not do anything and just wait. So and we know that we need to do this. then what should be done at that time?
Financial constraints on the part of the patient, or if the patients are violent, or if they are not able to, for example, procure medicines or something which is prescribed, definitely that has to be documented. Whatever is truthful and whatever you document always helps in long run.
Okay, but we cannot mention that because hospital management will question us that why, how can you write that in like negative about some consultant? So we, if anything happens, then we are like we are answerable. That why we have not done. Doctor has asked us on call. It was
If
decided
you
that
are,
you need to
if you
do.
can maybe later on, if you can tell me the specific thing, because this question cannot be generalized. If you tell that
Okay.
particular specific thing which has happened with you, definitely I will I will advise you.
Okay. Okay, sir, but I cannot disclose the name of the hospital or anything.
No,
Or-
you don't disclose on this forum.
Yeah.
You can. Drop. No problem.
Thank you, sir.
Thank you very much, Dr. Shikar. Any more questions? Can you raise your hands, please?
Sir, Dr. Faruqi from Pune.
Sir,
Sir, I want to know how many years we have to keep the documented at kept the documents at the hospital. How many years?
yeah. How many years? So if it is as per our this thing NMC, it is 3 years. They advise to keep documents for 3 years. However, I always advise OPD documents are to be kept, should be kept for 3 years, and IPD documents for 5 years.
Thank you.
And
Thank you.
if it is a medical legal case, then you have to keep it for forever. In fact, forever. And also, if you have received some legal notice, any doctor of your hospital has received some legal notice, then such documents also should be preserved till the finalization of the case, if it so happens. And one more thing is, even if there is no medical legal case, even if there is no legal notice, but if a doctor apprehends ki, yes, there was something wrong or something has happened, and maybe it will be found out at a later date, such documents also should be preserved for at least 20 years.
Thank you, sir. Thank you, sir. Thank you, sir.
Hello.
Yes, Mr. Tejas, then Dr. Avanti, and then we will end this question and answer session.
So one more question, please. Dr. Ritesh Mandal.
Sir, please speak loudly.
So one more question. Sir, if any resident doctor who is BAMS, BHMS or BUMS qualified, who is working in a cardiac center or any ICU, and suppose the patient come by any acute emergency like myocardial infarction or status epilepticus, and that patient is died in the presence of that resident doctor, and the owner of the doctor or consultant is not there, then who is responsible for that death?
You mean to say that owner is an allopathic doctor,
Yes.
and
Yes.
the junior or duty doctors are of other pathies?
Any Ayush
Okay.
path? Yes.
Yeah. So in this particular case, and for the situation in which the patient is, that is serious, maybe status epilepticus. So in such cases, there is no what you call it as this. Even if you enter at this stage in whatever capacity, in whatever may be your qualification, but whenever you face such situation, you definitely need to manage that patient critically, because keeping ABC, that is airway, breathing and circulation normal, so that is taught in all pathies. It is not only related to allopathy. So these things you can definitely do it without worrying about the whatever pathy, and inform the doctor urgently.
If doctor is failed to come and patient died in 1-2 hours, then
Yeah. then you should refer the patient in that case to nearby center.
And before referring, that patient dies.
Correct. In that scenario, you equate that scenario to a remote village where there is no allopathy doctor, where there is no facility of transport. In such cases, whatever you do in the best interest of the patient will be appreciated by the courts. It will not be taken in a negative manner, because you have tried your level best to save that patient. Only it should be in the benefit of the patient and in the best interest of the patient.
It means the working of the Ayush doctor in the allopathic center. It is okay for the patient and by law.
I am not at all commenting on the cross-pathy. I am only commenting on the situations in which you stated that a serious patient on the verge of death or status epilepticus, in such cases, whatever you do of whatever pathy, it will be not be taken as a case of negligence.
Okay, thank you, sir. Thank you very much.
Hello, sir.
Huh.
Hello, sir. I'm Dr. Avanti. My question is, if the patient is illiterate, means both the patient and his relative is illiterate, and we have taken the consent from thumb impression, and after treatment, some mistakes means some medico-legal issue happen, and the patient go through the court. Then what should we do, doctor? What should we do? Because there is a thumb impression and the patient is unable to read the consent.
That's why we take signatures of the witnesses. Witnesses are of two types. One witness is, they just witness that somebody has signed that document. And second type of witness is, in such cases, patients who are illiterate. That means they can speak a language, but they cannot read and write the language. In such cases, a witness has to witness the entire procedure. Whenever such witness is signing, they are signing for that all the pros and cons of the treatment, all alternative therapies, the cost involved, the length of stay, the qualification of doctors, everything has to be for the patients. Witness this and take this side. So here is the importance of witnesses.
Means the witnesses are not their relatives.
Witness has to witness that you have explained everything to the patient.
Okay, sir.
And then sign.
And if okay, sir, thank you. And the other question is, if a patient comes to us in emergency and there is no facility of emergency to our clinic, then we have to send him to the other center, but the patient is not patient is not ready to go to other hospital and say to us that you treat the patient here, and some happen to the patient, then what to do?
There are situations, such type of situations, they do occur sometimes. But the first thing is, if you are claiming yourself to be a doctor who provides emergency care, then you should be prepared for that. You should have those facilities and equipments and everything, the expertise you should have. But if you are not claiming that, for example, some hospitals, they do write on their hospitals 24 hours emergency services available, but the facilities are not available at night time. So this can be held as negligent. Yeah. But in such cases, if you do not have that facility, if you are not claiming that you are an expert or you are providing that facility, the patient is not willing to go to anywhere. That means you should accept some ambulance or some thing, and you should take that patient to the referral center. There are situations in which the patient refuses to go. In that case, we have a situation, because the patient or the relatives, they are not allowing the doctor to treat the patient. So that in that case, we have informed the police to intervene.
Okay, sir. And the management of ambulance, whose responsibility is that, the doctors and or the patient?
No, if you are claiming that you provide ambulance facility, then it's your responsibility. If not, then nowadays government has provided the facilities 108. You can call those.
Okay, sir. Thank you, sir.
Okay, Dr. Swapnil.
Yes, sir. If you didn't, if you didn't properly document it, it means you didn't do it. Thank you very much, sir. Honorable Registrar of MHS, Dr. Rajendra Banga, sir, explains us on the pitfalls in clinical documentation, importance of proper documentation and responsible documentation also. Dr. Banga, sir, emphasizes on proper documentation. Thank you very much, sir, for your valuable lecture.
Thank you. Thank you.
Yeah. Now I invite Dr. Ajay Patil, sir, Professor FMT Srimati Kashibai Navale Medical College and Hospital, Pune. He will guide us on the Consumer Protection Act and practice of Ayush. Dr. Patil sir has completed MBBS from BJ Medical College, Pune, Diploma in Forensic Medicine from Grand Medical College, Mumbai. His MD in Forensic Medicine and Toxicology from TN Medical College and BY Nair Charitable Municipal Hospital, Mumbai. He is also diplomat of a national board in Diploma in Industrial Safety, National Institute of Labor Education and Management, Associate Fellow in Industrial Health, Central Level Institute, Mumbai, Postgraduate Diploma in Forensic Science and Law from the Institute of Science, University of Mumbai. He is the life member of various national and international professional bodies. He carried out responsibilities of Chairman, Steering Committee of UNESCO, Chair of Bioethics. So now I request Dr. Ajay Patil sir to kindly deliver a lecture.
Before that, it is request to all, please keep your mic mute and please don't touch screen. If you are joining with mobile, then please don't touch screen, okay?
Dr. Ajay Patil sir.
Thank you, Dr. Swapnil sir.
Yes.
And thank you, Dr. Gitanjali madam. Very good afternoon, and I am very pleased today to be a part of this session. This particular session, which was started with Registrar Sir, Dr. Rajendra Bangal, and we would be listening to Dr. Sandeep Kadu Sir, Controller of Examination. I'm really, this is a pleasant experience. But before even starting the session, let me share my screen and guide me, Swapnil sir, whether it is visible.
Yes, sir, it is visible.
Yes, sir. So,
Please make
sir,
it. Sir.
thank you, Dr. Gitanjali madam. This particular topic is Consumer Protection Act and the practice of Ayush. I would rather want.
Sir, please make it in presentation view. Your slides.
Yes.
Okay, sir.
Is it okay now? Yeah. Is it visible, madam?
Yes, sir.
Thank you so much. So even before I begin the topic, let me give you an overview with which you would consider, because this is 30 minutes and I would be covering few areas of Consumer Protection Act and few about Ayush. But these will not be exclusive to each other, because I understand the principle or the spirit of this particular topic is when it is intertwined with each other. Apart from that, medical professional practices, relevant acts, government regulations, little history of 60, 70, 75, 80 years, and credentialing and privileging. So even before starting this, along with the excellent team of the university, state university, I also want to thank my management who's been very supportive and allowed me. But along with that, apart from my inputs from our own specialty people from allopathy, I took inputs from many of the Ayush practitioners and the leaders in that, as Dr. Dnyaneshwar, Dr. Abhinandan, Dr. Argade, Dr. Milind Kulkarni, Dr. Abhijit Angre, and so many. But because I wanted to know what is the status and what are the present issues. So let me begin. I would begin directly with the case of Indian Medical Association versus VP Shanta. I'll not go into the detail because we all know that. But the principal issue in 30 seconds was whether medical or practice is coming in under the ambit of service. Because once it comes under the ambit of service, there is non-tangible issue which is attached to the practice, and then it is deficiency of the service which can be proved. So 86 we are talking. But the court dealt with how a profession differs from vocation or occupation. But I'll not again go into the details, just establishment thought process. But the court noticed that medical professionals do not have immunity from being sued under the law of contract or tort on the ground of negligence. Having said so, patients and relatives generally have a prayer or their demand in consumer forum about monetary losses, either actual losses or presumed losses during the treatment or in future. And it has direct relevance to professional indemnity insurance procedures regarding Ayush practitioners. But how do the courts decide about privileging? Privileging basically who would be allowed to practice what diseases or circumstances or situations and up to what level. So privileging by the courts is based on various acts or law, acts of law, and then the government regulations which follow thereafter. Then the regional notifications, as we saw hundreds and thousands of notifications by the local authorities in pandemic or otherwise. Then the degrees, then the different acts related to drugs, pharmacy, cosmetics, and courts also do consider about medical education. So I'll not go to the theory part much, but directly to the next topic, that is, I would come back to consumer cases directly, and then how it translates or transcribes to Ayushpathy. So what is Ayush? The Ministry of Ayush was
Sir,
formed.
slides are not moving.
Not visible.
Slides are not moving.
Okay. So I will try again.
Just make it full screen, sir.
Yes, sir. This is full screen. Now, can you see the previous slide, or is it moving now?
No.
No. Need to start slideshow.
Okay. Give me a minute. Okay. आपल्याला वाटतंय तिकडे पण व्हायला पाहिजे. Sir, can you read the slide which says meaning of the word Ayush now?
No, sir, no. It is only a title slide.
If you can make full screen with slideshow, it will be visible to all.
Now it is
Visible है sir.
Now it is moving.
Yeah, yeah. It is moving now. Yeah. Now please make it in a presenter mode.
Now
Or
is
is
it? Yeah. Is it okay now, ma'am?
Yes, sir. It is okay.
Okay, so the Ministry of Ayush initially was Indian System of Medicine and Homeopathy, but then it was from 95. And meaning of word Ayush in English is basically, we know that, but what we in fact is a new addition is about Sowa Rigpa and naturopathy. Obviously it was old. So this is from the website of Ministry of Ayush, but this is from the website of Ayush Next. Torne sir, Swapnil sir, can you see the slide of Ayush Next now?
Yes, sir. Ayush
Okay, thank you. Okay, so Ayush Next basically is again by the same ministry, and is a digital powered initiative of the Ministry of Ayush, which is for broadening the sphere of information exchange, because it warrants that as we are talking about Ayush visa or a green channel for foreign nationals to come here, not only for medical tourism, health tourism, but also for wellness tourism. So Ayush Next is also a platform by the same ministry, and it talks about Sowa Rigpa as the addition. So just in nutshell, recently Honorable Union Minister in a written reply to LAQ elaborated that memorandum of associationship with Ministry of Railways and Ministry of Defence for the establishment of new Ayush wings and defence, and in defence and railway hospitals. So we can see or fathom or feel or palpate the direction in which the government or this particular process needs to be executed. Or what is Sowa Rigpa? Sowa Rigpa is one of the 7 Ayush systems, which is one of the oldest and documented in traditional world. But it is from Bhoti language and means knowledge of healing, but it is in the Himalayas. So this is a new addition. Madam, can we see Supreme Court of India slide now?
No, sir, no.
Oh my.
Sir, I will request you. Please share your slides again. And then go to third slide.
First slide. I'm so sorry.
No. Hello.
Madam, yes.
Sir, start it from beginning.
I will do that, madam. Okay, this is the first slide I am able to see. Madam, is it first slide for you? I'm so sorry.
No, sir.
I'll stop sharing and then again start sharing.
सर अगोदर तुमचे जे काय असतील ना तुम्ही ओपन केलेले ते पण क्लोज करा सर याच्यामध्ये. मग ते काय होतं की पॉवर पॉईंट हा आता सुप्रीम कोर्टचं आलंय आणि याच्यावर जा ना सर आपल्या स्लाइड शो मोडवर.
हो सर. आहे का सर आता?
आता आहे सुप्रीम कोर्टचं पण स्लाइड शो मोड येत नाही सर.
मी स्लाइड शो मोड केलाय सर आणि मला दिसतोय पण मी पॉज करून परत हे करतो.
रिझ्यूम स्लाइड शो मॉड्यूल हे बघा सर आलंय तुमचं त्या खालच्यावर आहे का? त्याच्यामुळे प्रॉब्लेम होतोय. स्लाइड पुढे जाता येते. ठीक आहे जाऊ दे सर.
डॉक्टर कडू सर कोणती स्लाइड दिसत असेल आता?
आता पहिलीच आहे. पहिली जी आहे तुमची
टायटलची स्लाइड दिसते सर.
आता काय बरं का सर तुम्ही क्लिक केलंय तिथं स्लाइड शो आलंय. आता त्याच्या खाली रिझ्यूम स्लाइड शो त्याच्यावर एक येतंय आम्हाला दिसतंय इथे.
रिझ्यूम शेअर रिझ्यूम स्लाइड शो कशात येईल? ओके.
खाली एक स्लाइड शोच हे असतं सर.
येस सर.
हा करा त्याच्यावर क्लिक बरं सर.
केलं सर.
नाही एकच मिनिट थोडं. नाही आलंय पण सर घ्या पुढची स्लाइड घ्या याच्यावर की असे ना बघूया मूव होते का बघा बरं सर.
आता मी आहे 12 नंबर स्लाइड वर समजा असं मला वाटतंय.
हो पण आम्हाला दिसते 1 नंबरची.
1 नंबरची स्लाइड दिसते सर.
एकच मिनिट द्या सर.
हा ठीक आहे. हा आता असं करा आता पूर्ण हे करा आणि परत शेअर करा.
हो सर.
आणि बाकीचे सगळे पण बंद करा सर. पहिले पॉवर पॉईंटचं परत ओपन करा म्हणजे मग ते होईल.
पीपीटी म्हणतायत का? ठीक आहे. एकच ओपन.
बोला.
मुक्तियार चांद झालं सर.
अच्छा हा 14 नंबर आहे सर स्लाइड म्हणजे अच्छा ठीक आहे सर आलं लक्षात. आता सर सुप्रीम कोर्ट ऑफ इंडियाचं दिसतंय सर.
माझ्या लक्षात नाही होत. नवीनच कर नवीनच कर. ते जगदीशच्या याच्यावर न केलेलं माझ्या याच्यावर नाही होत. हे बघ. हा पाठवून दे. आता स्लाइड मोडवर जाल सर.
Mathur sir. I
Yes, sir.
request Mathur sir kindly look into the matter whether the is there any technical hurdles.
I just go into it, sir.
स्वप्नील सर कोणता असेल तो स्लाइड दिसते
आता आहे.
Dr. Mukhtiar Chand and others ची दिसते sir.
ठीक आहे सर सर मी कंटिन्यू करतो
हो करा सर करा
sir. Sir, in Supreme Court of India, the case, which is a landmark case, decided way back in 98. Basically, the petitioner was Dr. Mukhtiar Chand, and then the questions of the right to practice medical profession and the right to life. This was vehemently discussed for the first time, and in vis-a-vis with governments under the clause and rules of the Drugs and Cosmetic Rules and Drugs and Cosmetic Act, but the rules in 1945, which defines registered medical practitioner. But under such declarations, notified where Hakims claim right to prescribe allopathic drugs covered by Indian Drugs and Cosmetic Act 1940. Sir, slide मध्ये डॉक्टर सरवन सिंग दिसतंय का वर आहे चला okay sir, in this particular Mukhtiar Chand case they took a reference of Dr. Sarwan Singh Dardi, this particular case which in which basically he was with the Board of Ayurvedic and Unani System of Medicine in Punjab, and there was an order by the district drugs inspector saying that he cannot keep in his possession any of the modern allopathic drugs for administration to the patients. And then this was pleaded in the court of law that the action of the inspector was questioned by Dr. Dardi, obviously, and he claimed that he was covered by the said notification of that particular Drugs and Cosmetic Act, entitled to prescribe allopathic medicines to his patients and store such drugs for their treatment. The division bench of the Punjab and Haryana High Court in judgment in 86 way back held that the said notification was ultra vires, meaning by it supersedes its limits or it is beyond its rights. The petitioner holds a degree of BMS from Maharishi Dayanand University, Rohtak. He asserts that on the basis of the said degree, he is entitled to practice modern scientific system of medicine. Now, these words are very important. Rather, key words when it comes to government regulations, its references in various acts and courts, the judgments of the courts. A degree holder in intended courses is imparted not only the theoretical knowledge of modern scientific medicine, but also the training thereunder is the claim. I am reading every word, sentence, comma, or full stop right from the judgment of the cases and not from any other vocabulary. So that thereby we would get and feel what the benches, honorable judges, or the juries want to convey. The bench over here states a person can practice in allopathic system of medicine in state only if he possesses recognized medical qualifications. Permitting a person who does not possess the recognized medical qualification in the allopathic system of medicine would be in direct conflict with the provisions of Central Act. I would go further and then explain it back in simple terms, but I wanted these judgments are voluminous. But I'm in the process, I tried to squeeze it for the sake of easy understanding. Court further states that we shall examine the notifications issued by Central Council to ascertain the importance of those keywords, as I stated. And what are those? In the next line, you would be able to read the concept of modern advances or modern medicine. It is unanimously resolved that in clause for the modern advances under various branches, modern scientific system of medicine, clinical, non-clinical biosciences, and technological innovations like investigations made from time to time, the courses and curriculum, syllabus and curriculum conducted and recognized by CCIM are supplemented by such modern advances. And the last slide to explain it in simple language. What does it mean? Now, all this legal jargon, in fact, this goes, the judgment itself goes into hundreds of pages, 500, 600 pages. But it states, the court stated or the judge stated that the advances made in various branches of modern scientific medicine, clinical, non-clinical, technological, and it is incorporated into the courses, curriculum, syllabus, and assessment system of Central Council of Indian Medicine colleges or the institutions. So the Board of Studies, they would go through, adapt to those, try to incorporate, try to modify, delete few, add few, and then impart it to the next batches. So on October 30th, clarification notification by the government, it says institutionally qualified practitioners. That is Ayurveda, Siddha, Unani, and the institutions which are recognized, approved by the government, regulatory or statutory bodies. And what does it allow to practice? It allows to practice modern medicine, including surgery, including gynecology and obstetrics, based on the training and teaching, which now I would take you further. See another case, Chandigarh Nursing Home versus Sukhdeep Kaur, decided in 22. Complainant was a minor, that is a girl, and she said the doctor who treated is a BMS doctor, that is Ayurveda, and not competent to prescribe allopathic medicines. But the district forum awarded 1 lakh rupees as a compensation. State Commission dismissed the appeal and said that's fine because the complainant went ahead for asking more compensation, and then National Commission enhanced the amount to 10 lakhs. Being aggrieved, now the doctor went to Supreme Court, and then Supreme Court subsequently disposed of, saying that 10 lakhs is an appropriate amount for compensation. So no two cases or no two judgments or no two landmark so-called precedence judgments are similar or would hold water for long term, but they would get repealed by the next case. So whether now the questions, now you would understand by looking at the questions that these are Legislative Assembly questions, LAQ, in the Legislative Assembly, whether the doctors of Ayurveda are banned to conduct surgery. This is a question, which is a relevant question asked to the member of Legislative Assembly or the public representative. If the answer is no, they are not banned as of now. And at this present juncture when we are speaking, and if so, the details thereof, whether the government proposes to allow doctors of Ayurveda to perform surgery, if so, details thereof, and if not, the reasons thereof. The aims and objectives of Indian Medicine Central Council Postgraduate Ayurveda Education Regulations 2016, published in the Gazette with Extraordinary Part 3, says to provide orientation of specialties of super specialties of Ayurveda. Means what? It means efficient teachers, physicians, surgeons, gynecologists, obstetricians, that is Sri Roga, Prasuti specialty, pharmaceutical experts, and Prasuti Tantragya, and that is, I think, technician, and researchers, profound scholars in various fields of specialties of Ayurveda. So the regulation allows, now I am coming to the easy part of it. Swapnil sir, please guide me. Regulation allows, या स्लाइडला आपण बघू शकतायत का?
नाही सर, ती आपली
ही स्लाइड आहे सर मुकंदर
आदर्शित स्लाइड आहे.
पाटील सर जाऊ दे आता, आपण कंटिन्यू करा सर. हो,
Okay, ठीक है. So the regulation allows postgraduate degree in surgical branch in Ayurveda, that is Shalya. Then Shalakya, which is eye, ENT, or that is ophthalmology, ear, nose, throat, or dentistry. And then Srirog Prasuti Tantra, that is gynecology and obstetrics. So PG degree courses, MS Ayurveda are of 3 years duration and after the course of BAMS. Basically, with the medical education and drugs department and with this particular thing, there is a gazette notification. I wanted to draw your attention, but unfortunately, I'm not able to show it. Another landmark case in Uttarakhand, in Sanjay Singh Chauhan case, it says that unreasonable classification and discrimination based on discrimination between allopathy and Ayurvedic practitioner would surely inconsistent with Article 14 of Constitution of this country. It means, what is Article 14? Article 14 is a right of equal legal protection. So it goes to say beyond a doubt that this discrimination, not to everybody, not blanketly, but to the people who are who have studied undergraduate and postgraduate degrees in approved institution, are basically allowed to practice to certain extent, and that privileging is already decided. So a doctor holding, basically, I'll not go to this particular case because everybody may be knowing Ashwin Patel case, so I would skip this. Basically, there were few cases. I am not sure whether you and I don't think you are able to see those, but the candidate, if it is incapable to undertake independent work in surgical procedures and their management in the respective specialties, the consumer court per se draws attention into 2 areas. One, whether the institution from where the doctor was qualified was recognized at that particular time, and another thing is whether this particular thing was included in the syllabus and curriculum, not now, but when at that time when the doctor was undergoing that particular training. So the minutes of the Board of Studies, the syllabus, the curriculum. So the courts basically nowadays what we call as logbook or the competency books. So courts are interested to look into the expertise of the doctor based on what supervised surgical or otherwise work he has undertaken. Then this is one, and another thing is whether he was allowed to do that by the statute or by the act and by various amalgamation or grid of that particular act with the educational system. So that is where universities and the syllabus and the curriculum is very important when it comes to minor privileging or highest privileging. For example, putting a central line or doing some cardiothoracic surgery. And then when the court goes back 30 years back and says whether this particular type of training was imparted and then decides upon the privileging. But in view of the clarifications, there are different clauses of sections of the Central Act, and whereas private medical practitioner is, if he is competent or whether he is trespassing the limits of his areas of expertise or specialty is decided upon. So why I am talking about few judgments of the Supreme Courts, I wanted to show really with the precision that few landed to High Court and Supreme Court. Though it is not my topic, the topic is consumer courts. But please understand that these are the appellate authorities. Once this particular national commission, this particular prayer or remedy is exhausted, it is an appellate authority. So these are basically consumer litigations or prayers which landed to high courts. The High Court of Andhra Pradesh, there is a wonderful landmark case which says that it is protected under 17(3)(b) of the Central Act, that is the modern scientific system of medicine, allopathic medicine, what it transpires, how it is to be dissected for understanding. And then there is a case where it says the charges of the petitioner are groundless. It is the right of the accused, if the accused who is a doctor, if it is the right of the accused and if the doctor is qualified in a approved or rather in a recognized institute with that particular kind of a training, first supervised. Nowadays there are skill labs, then there is a supervised training, and then they do some things hands-on, and then they go to the practice. So if these are demonstrated, then these particular doctors who may be accused, they have right to get discharged from all these charges. Now, few cases against insurance companies and third-party administrators, like Pune District Forum case, Mr. Ismail Abdul Saeed versus Oriental Insurance and MD India, that is a TPA. The TPA rejected the claim, mediclaim, stating that this particular doctor is not allopathy, but he has given allopathic treatment. And they have their own clauses for giving an insurance policy. But the district forum and the honorable forum considered the fact when it was pleaded beyond doubt that this particular Ayurveda practitioner was allowed to certain extent, to the extent where he practiced and given a treatment, then this insurance company and third-party administrator were reprimanded. In fact, the district forum here in this particular case says what is a medical practitioner is a person of any state of India or council for Indian medicine or for homeopathy set up by government of India. So they went ahead. In fact, they went ahead, the Pune District Forum, and said the insurance company, the complainant was taking medical treatment, and if it is rejected on not understanding the point of law or spirit of law, then on these main grounds and other grounds set out in written version, party number 1, that is insurance company.
Sir, can we conclude here?
Last, and it says
the next meeting.
I'm so sorry, I'll finish in last 2 minutes. The complainant is also entitled to compensation towards mental harassment, agony, and cost of the complaint. So the judges or the bench went ahead. Nowadays, Central Consumer Protection Authority states certain medicines in Ayush, informing the stakeholders that no online purchase of or sale of these medicines can be done. I'm really sorry for the technical glitch, but I would request Madam Dr. Gitanjali and Kadu sir that I'll send across the presentation, and then also would find out certain time where I could answer back with the queries. Thank you, Dr. Bangal sir, Dr. Kadu sir, Dr. Gitanjali madam, and thank you everyone.
Thank you, Dr. very much, Ajay Patil sir, for your valuable guidance. Dr. Patil sir guided us on the Consumer Protection Act and the practice of the Ayush. He gave the various examples of Supreme Court and High Court decisions also. Thank you very much. Now I request Control of Examination, Dr. Sandeep Kadu sir, to give his presentation. Dr. Sandeep Kadu sir is the best teacher awardee of MHS. He is having the vast teaching experience for almost 23 years. He authored and edited 8 books, having 3 patent and 4 copyrights, and near about 50 publications on his credit. His areas of interest specifically in medical research and medical education technology. He is the resource person for medical education technology research methodology workshop of MHS and various other authorities also. He is the editorial board member of various national and international journals. So I request Control of Examination of MHS.
Thank you, Dr. Torne sir.
Will guide us on the medical certification of cause of death and injury report. Welcome, sir.
Thank you, Dr. Torne sir. Am I audible and my slides are visible?
Yes, sir.
Yes, sir. Okay. At the onset, I'm very thankful to our respected Honorable Vice Chancellor ma'am. The meetings like this are a brainchild of her. Also, I congratulate Dr. Gitanjali Karle madam for the initiative. Our respected Registrar, Dr. Bangal sir, my friend and very knowledgeable legal person, Dr. Ajay Patil sir, for their knowledgeable talk. And also my sincere thanks to Dr. Torne sir for the nice introduction.
Thank you, sir.
So, with this, today's my topic is of 2 certificates, but as time is less, I'm going to concentrate only on one certificate, that is the MCCD, that is the Medical Certificate of Cause of Death. And next time we'll again have a such type of the Zoom meet. In that again, Dr. Ajay Patil sir, or respected Banga sir, and I will be there with another topic. So the first hand, there are many students I have seen. Each one has a dream to become a successful doctor. So what are the things needed and what are the things should be inculcated in the minds of new budding doctors? These are the few things. It's my copyrighted slide. That is, the society give you respect as a next to God. Keep this in your mind throughout your practice. That society gives you respect to next of God. So our behavior, our speech, our attitude, that. Second, do your practice ethically. And I promise all the budding doctors that if you do the practice ethically, within 5 years, whatever your dreams are there, Gadi, Bangla, whatever the thing, they are going to come true. But you should practice ethically. If you practice unethically, within 1 or 2 years, you get lot of money, but one thing will happen and it will vanish all. So do practice your ethically. One of the curse to our all the medical profession, I don't like the word profession, it is the service. Now it is the again debatable, but my personal view that it is still service. If you consider that I am doing the service, then your practice or you will do your practice ethically. The one of the curse is that the cut practice. And those who are listening, budding doctors, so don't take any cut money or don't give the cut. If you are doing any investigation, are you going to do that investigation on your mother, father? Is it necessary? If it is necessary, advise to your patient. If it is not necessary, don't advise him. So do your practice ethically. That second thing must inculcate in the new coming doctors. Be skillful in art of healing. In our NMC document, there is one important thing that you should be skillful in art of healing, not art of killing. There is one act, that the PCPNDT Act. And in PCPNDT Act is only for to decrease the female feticide. There are many reasons are given. The why they need the female child or they need to the male child. But we doctor, if decide that we are not going to do the sex determination, no layman can do the female feticide. So it's on us. So you should not tell the patient do the sex determination. That is the one of the things. Be empathetic with your patient. Don't compromise for the illegal thing. This is the most important sentence in your life. If you compromise once, you have to compromise for that illegal thing throughout your life. So my friends, don't compromise any illegal thing at once. Again, I'm repeating, if you are going to compromise for it once, you have to compromise that thing throughout your life. And remember Newton's third law, that every action has equal and opposite reaction. If you will do good things will happen with you, and the vice versa. So with this introductory note, I'm going to come to my present topic, that is MCCD. That is the Medical Certificate of Cause of Death. So a birth or death has to be reported to the registration within 21 days of the occurrence. Birth and death registration to be done at the place of the occurrence. If the person is living in Nashik, but he is hospitalized in Pune, and unfortunately death occurs, then that should be registered in not at Nashik, but at Pune. So the place where the death and birth occurs, that place only it should be registered. Any death after expiry, the normal period is 21 days. If you are not able to register that, within the 30 days, it can be registered with the late fee. Even if you are not able to register within 30 days, up to 1 year, it can be registered with the permission of the prescribed officer in the behalf of the late fee. So you have to take the permission of that prescribed officer. And if you are not able to register within 1 year or so, then that can be registered after the court order. These are the things related to the MCCD. So it is common and third rank many times that we say that we give the death certificate. But remember that the wrong thing in the minds of the registered medical practitioner, we always give medical certificate of the cause of death. That is, we give the cause of death certificate, and death certificate is given by a particular authority. If it is of in village, there is the Gram Sevak. It is of a taluka place or municipality, then there is the register of death and birth and death register is there. That person issues the death certificate. So remember that we always issue the MCCD, that is Medical Certificate of Cause of Death. And the important thing about this is that this format is prepared by the WHO, that is World Health Organization. Means this format with certificate is same throughout the world. So that is the peculiarity and the uniqueness of this MCCD. So It is in a form of 4 and 4A and going to come on that point. So this is the pro forma of the medical certificate of the death, that is name of hospital, then the name of disease, male, female, then cause of death, then manner of death, and all these things. Then is the basic difference between form number 4 for the deaths occurring in a hospital and form number 4A for the non-institutional, means at a clinics or small OPDs if the death occur. That is the form 4A. The basic difference between the form 4 and has the details of the hospital where death is, while form 4A has the details of the attending doctor and manner of death is not mentioned in the form 4A. That is the basic difference between the form 4 and 4A. In short, form number 4 is deaths occurring in the hospital or institution, and form 4A for the non-institutional deaths. Now I am going to come into the small explaining each thing. That is the medical certificate of the cause of death. The first is name of the hospital. You have to write the name of hospital. Then, so it is the form number 4. I hereby certify person whose particulars are given below died in the hospital, ward number, date, and the time, AM and PM. Then name of the deceased, sex, male or female. Then age, if it is if more than 1 year, age in 1 year. If less than 1 year, then it's in month. If less than 1 month, in days. And if it less than 1 day, then in hours, you have to mention the age of that disease. Is it clear? It's a very self-explanatory. It is the heart of the MCCD. So here, as a medical practitioner, you have to give your expertise opinion. So, name of disease, you know, all these things you have filled. Then cause of death, it has 2 Romans. First Roman is the immediate cause, and in first Roman has the 3 types, that is the small a, small b, small c. Then C is the basic cause of, where C gives B and B gives A. A is the immediate cause of death. I'll explain afterwards, but for time being, remember that it has the 2 things, that is the Roman 1 and Roman 2. Roman 1 has again small a, small b, small c. C is the basic, C gives B, B gives A. Then next column is the interval between the set, means the C, how many years? For example, if it is the hypertension, from the hypertension, if the hypertension is the basic, 10 years, hypertension has given the atherosclerosis, then atherosclerosis has given the myocardial infarction. Like that, you have to write the time interval also. And the other is the other significant condition contributing the death, but not directly related. For example, that person also suffering from the arthritis. So arthritis does not lead directly to the death. So you can write in a Roman 2, that is the arthritis. Now understood that the important thing. Again, here there is again the ISD codes are also there. So the ISD codes are there is app also. You have to put the name of the disease, that will give that code, ISD code. So that ISD code is for the statistical use. Because afterwards, how many persons are dying from the myocardial infarction from India, from that Maharashtra, from Ahmednagar or Nasik, like that. If you want to take the data, it's very useful to use the ISD code. Same thing, that is the part 1. It has A, B, C, and as well as part 2 also. And approximate interval between the onset of the death. This is the proper where, as a medical expert, we have to write a proper diseases, or from where the disease has started and for what is the immediate cause of death. Then next is the, as it is the institutional death, then it is the manner of death. If it is natural, then and then only you are going to write this C, B, A. If it is unnatural, then you don't give the cause of death. Cause of death is given after the medico-legal postmortem examination. Then if disease was a female or pregnancy death, at that time, if it is the that female is pregnant or not, you have to write. And if yes, was there is a delivery. If yes or no, that's also the self-explanatory. Name and signature of medical attendant certifying the cause. Here you have to write your full name, your designation, your registration number, and the signature. All these things should be filled here. And this is the part we give to the relatives. And on this the other funeral and other activities can be done. In that there is Amardham and all this, they require this certificate. And only this part is given to the relatives. That is certifies your son, widow, daughter of Sri, so residence, was admitted to hospital and expand on this, and your signature. So this is all the small part of the MCCD. So now I will come give some examples so you can better understand. That is, if it is the duodenal ulcer, C gives due to duodenal ulcer, perforation of the duodenum has occurred, and due to the perforation, peritoneum. So immediate cause of death is the peritonitis. And there is the part that is the part 2 is the carcinoma of the bronchus, that is not directly related to the cause of death. Then if the person is alcoholic, he has chronic alcoholism, which has given the cirrhosis, and cirrhosis has given the hemorrhagic shock. So that is the hemorrhagic shock is the immediate cause of death. And diabetes mellitus is not directly related, but it is the other thing. Then if it is there is hyperlipidemia, has given the atherosclerotic heart disease, and atherosclerotic heart disease has given the acute myocardial infarction. There is no necessary to write down. If there is another part 2 is not there, though leave it blank. So important points for the RMP at the time of the insurance. RMP should not delay for any reason issuing the medical certificate of the cause of death. And it should reach within the 14 days of the occurrence. RMP cannot charge any fees. Many times what happens, the patient is get admitted in the hospital. After all the treatment and this, the unfortunately patient dies and he has the bill of 2 lakhs, 3 lakhs. Many hospitals detain the dead body until the bill has not paid, but it's the wrong. You should not delay. What I suggest, and many times in a hospital, the conflicts have occurred due to this reason. You can understand on a humanitarian ground, these all people are in the very bad emotional mood. And if you are telling to pay our bills, then I tell you we are going to give the dead body, that's not good. Then you will say, then how that bill will get paid? At that time, use your sixth sense. You can recognize or you know that this patient is from 15 days. One of the mature relative is there. Recognize that, call him, tell that now I am giving the body because the death has occurred, but my bill is there within 15 days, 20 days. After that, you have to pay my bill. And we are in India. 99% the people pays their bill. But my request to all, don't detain the body for the non-paying the bill. Or 1% is there. If they doesn't pay the bill, you can go to the court and from the court's order, you can get your bills. But it's a very sensitive matter. So my request to all new doctors that remember this. Don't detain the dead body for the paying your bills. Don't take any charges to give the MCCD. You can take the charges of giving the true physical fitness, true medical sickness certificate, true medical fitness certificate, but you should not take any charge to issue the MCCD. RMP should not withhold issuance of the medical certificate of the cause of death if is not cleared I have already explained. And no medical officer should sign the medical certificate of cause of death in advance. Many times it has been happened that in a hurry or this you have declared and the body has came to the postmortem examination, and you are going to take that it's not the joke, but the things has been happened, that because you have not taken a proper care, or this one 5 minutes you have to hear this one 5 minutes feel the pulse, or if you are in doubt, then take the ECG. So after that, only confirmation, only you have to declare the death. When not to issue the MCCD? You know that the MLC cases, broad dead cases, then crime has already been registered by the police. We have informed that MLC has been done, and you don't know the cause of death. In that case, don't issue the MCCD. So in case, if it is an unnatural death, means suicide, homicide, accident, body should be handed over to the police, who holds an inquest and send the body for the postmortem examination. However, the doctor is responsible to inform the registrar about the occurrence of the death. The registrar can note that event of the occurrence of the death and mention in the column of cause of death, then the inquest report is awaited. So I think with this, I have gone in detail each point related to the MCCD. My another topic is of injury report, but I already told that I will take it afterwards. Thank you very much. If any questions, most welcome.
Yeah, session is now open for question and answer. Is there any query?
Sir, this is Dr. Harish.
Yes, sir.
Yeah. I want to ask that it is a very common scenario that your neighbors call you when some elderly person is unwell or is may succumb to the last event. Now you are not attending that patient previously, and during resuscitation or something, the patient may expire. So in that case, you are having no history of that patient. Otherwise, you may get to see some medicines like antihypertensives or anything. And then from the general observation, we are going to make the comment about the cause of death, that it is MI or something, or we have to do ECG always of the dead patient also, or like what, that final cause of death. When we are seeing the,
I'll go to your point number one.
Hmm.
If the neighbors has called, if you know the patient, if you know patient, you have given the treatment, then and then only you give the MCCD. If you don't know, only on emergency basis has been called, better way or on a defensive way, that you should not issue, that you can tell them that go this one. You can take the patient to the hospital, and in that proper hospital, that doctor will say, and as a broad dead case, they can do the further thing. But if you are not sure, if you are not treated, then the on a defensive this, don't give the MCCD.
yeah. So if you are seeing the patient for the first time and the patient is dying, it is better to not to
At
give.
least it's given in that at least 10 days or 15 days, or is your routine patient, then and then only you can get this one.
Okay. Yes, sir. Thank you, sir.
Again, I'm very thankful to the organizer for giving me this opportunity, to our honorable respected Vice Chancellor ma'am, Registrar sir, Dr. Gitanjali Karle madam. Thank you very much.
Thank you so much, sir. Thank you so much for your very expert opinion regarding MCCD. Thank you, sir. Now, it is immense pleasure to me to deliver the vote of thanks for this webinar. I would like to thank our beloved Vice Chancellor ma'am, to Pro Vice Chancellor sir, then Registrar and today's expert faculty for this webinar, Dr. Bangal sir, for his expert opinion, expert guidance regarding documentation. Then Dr. Ajay Patil sir for Consumer Act, and our controller of examination, Maharashtra University of Health Sciences Nashik, Dr. Sandeep Kadu sir, for his very ethical guidelines regarding MCCD. Thank you so much. And last but not least, thanks to audience, thanks to all participants for a great response. Thank you. Feedback form is there. Please fill up.
Ma'am, you are sharing feedback form.
Please share the feedback form.
Ma'am, are you sharing the feedback form?